So what if the standard 23-person grand jury in America, the one you always hear about handing down indictments on the evening news, what if that was intentionally designed by the government to be exactly two people short of, like possessing the absolute unreviewable legal power to just dismantle the state itself?
I mean, the sources we are examining today, they actually argue exactly that capping a grand jury at 23 is this deliberate sort of mathematical strategy to prevent the public from triggering what is essentially a constitutional nuclear option.
Right.
One that's existed since the year 1215.
Okay, let's unpack this.
Yeah.
Welcome to another deep dive. Today, we are immersing ourselves in, honestly, a massive stack of highly controversial, profoundly alternative historical and legal materials.
Yeah, it's quite the collection.
It really is. So we're looking at this dense step-by-step manual, and it's titled Allodial Title via Land Patents. That one was authored by Joe Stevens, and then later on, heavily revised by a guy named Augustus Blackstone. And we're pairing that manual with just this vast, sweeping collection of lectures, transcripts, and study guides from a curriculum that's entirely focused on common law and court procedures.
Right. And specifically, as we get deeper into the actual mechanics of this, this alternative legal universe, we are going to be zeroing in heavily on Law Lecture 801.
Yes, Lecture 801 is wild. But before we get there, we need to set the stage.
Exactly. Before we delve into the mechanics of these texts, I really want to establish a firm baseline for our analysis today.
Please do.
Because the viewpoints, the legal theories, the historical interpretations presented in these sources, they challenge the very foundations of modern government.
The banking system, property law, all of it.
All of it. So we are here to impartially report on the content provided in these specific materials. We're not endorsing these views, nor are we, taking sides on their validity.
Right. Our mission is strictly to synthesize the original source material.
Exactly. The goal is for you, the listener, to understand the concepts, the terminology, and just the really intricate logic of these arguments exactly as the authors and lecturers present them, without any external editorializing from us.
Yeah, we are basically acting as your guides through this incredibly detailed alternate operating system for American law.
That's a good way to put it.
But before we can even begin to touch the immense, world-shaking power of this theoretical 25-person grand jury we mentioned at the top, we have to understand the inciting incident.
Right. Why are they so mad?
Exactly.
Yeah.
We need to know why the authors of these texts are fighting the modern legal system in the first place. And that battle starts, quite literally, with the dirt under your feet.
Yeah, the core assertion in these documents is that you don't actually own your house or your land or your property.
Which sounds crazy to most people.
I know, it sounds absurd.
Well-
But the concept of the illusion of ownership, that is the foundational premise of the allodial title via land patents manual.
Okay, so break that down.
So, Stevens and Blackstone, they argue that modern homeowners are basically operating under a carefully constructed legal fiction.
A legal fiction.
Yeah, like when you finalize the purchase of a house today, you get a warranty deed, or maybe a quitclaim deed, or a trust deed. And the modern world views that piece of paper as ownership.
Sure, you get the deed, you own the house.
Right. But the sources, they categorize those documents strictly under a legal doctrine known as color of title.
Color of title. I mean, the phrasing itself implies a facade,
Exactly.
It looks like ownership. It kind of mimics the function of ownership in your daily life, but legally it falls short of actual possession.
Yeah, the texts define color of title as an instrument which has the appearance of title, but in reality is not title at all.
Wow.
And they rely on really specific historical court rulings to justify this claim. For instance, they quote a case, Joplin Brewing Co. v. Payne, and they use that to assert that any instrument may constitute color of title if it purports to convey the title, even if that conveyance is ultimately void or, legally deficient.
So even if the paperwork is flawed at a fundamental level, it still acts like a deed.
Right. Because you only hold this color of title, the authors argue that the state and the federal government have essentially maintained the true underlying claim to the land itself.
Okay, so let's ground this in a practical analogy for the listener. Based on this framework, having a regular warranty deed is like thinking you bought a car outright, but the dealership secretly kept you on this inescapable lease agreement.
That's exactly it.
Like you have the keys, you put gas in the tank, you park it in your driveway every night, and all your neighbors think it's yours.
Right.
But the second you stop paying that yearly mandatory fee to the dealership or I don't know, if you violate some minor rule about how you're allowed to paint the car, they have the absolute legal authority to just send a tow truck and take it back.
That captures the mechanics of their argument perfectly. Because the government holds the true paramount title, they are legally permitted to subject your property to a myriad of burdens.
Burdens, meaning taxes.
Exactly. This is why you must pay perpetual property taxes. This is why zoning boards can dictate what you build on your land.
Oh, right, and why building inspectors can fine you for making modifications without a permit.
Yeah, exactly. In the framework of these sources, you are not a landowner. You are essentially a tenant functioning on a modern feudal estate, and the true landlord is the state.
And true ownership, according to these sources, is this concept called allodial title.
Yes.
Explain the mechanics of allodial ownership, because they view this as the absolute holy grail of property rights.
The term allodial, it signifies absolute ownership. It means the land is held free from any superior landlord, free from any sovereign overseer, and crucially, it is not subject to any feudal duties or burdens.
So in the context of this manual, the primary feudal burden they're targeting is the property tax.
Oh, absolutely. If you hold land in true allodial title, they argue the state has no jurisdiction to tax it, to regulate it, or to foreclose on it if you fail to pay those taxes.
Because it's yours. Completely.
Right. You are essentially a sovereign nation of one on your specific plot of earth.
Now, the manual doesn't just treat this as some abstract philosophical theory. They claim this absolute ownership was actually the original design of the United States, and that it was systematically stolen.
Yeah, they have a whole timeline for this.
They point to a very specific year where the architecture of ownership was fundamentally altered.
They trace the grand shift to 1913.
1913?
Yes, specifically pointing to the passage of the Federal Reserve Act.
Oh, the Federal Reserve.
Yeah.
It always comes back to the Federal Reserve with these theories.
Always. The narrative presented in the manual is that prior to 1913, vast tracts of land in the United States were patented and held in true allodial title by American citizens. But with the creation of the Federal Reserve System, the authors argue that a massive, quiet hypothecation occurred.
Okay, let's define hypothecation for the listener, because that's the mechanical lever of this alleged theft, right?
Yes, it is.
So hypothecation is when you pledge an asset as collateral for a debt without actually transferring possession of the asset. Like you keep the house, but the bank holds the underlying claim if the debt isn't paid.
That is exactly how they frame it. The manual claims that all land, all property, and essentially the future labor of American citizens were secretly hypothecated to the Federal Reserve Bank.
And why? What was the point?
The purpose was to back what the authors describe as a fraudulent, non-payable federal debt.
Ah, good.
Because the federal government was borrowing fiat currency from a private central banking system, it needed collateral.
Right.
And the authors argue the government offered up the paramount title to the land of its citizens as that collateral.
Wow. And they weave in quotes from the founding fathers to support this whole narrative of banking tyranny.
They do, yeah.
Like, they lean heavily on quote attributed to Thomas Jefferson in their materials. It's the one that warns that if private banks ever control the issuance of currency, the people will wake up homeless on the continent their fathers conquered.
Yes, that's a cornerstone quote for them.
So in the timeline of this manual, 1913 is the exact moment Jefferson's nightmare became a statutory reality.
Exactly. And to understand the depth of this perceived theft, the authors insist we have to look backward. We have to trace the genealogy of land ownership all the way back to the Norman kings of England.
Okay, medieval history time.
Yeah, this historical context is vital to their argument. So before 1215, under the feudal system brought by William the Conqueror, the concept of allodial title was exclusive to the crown.
Meaning the king owned literally everything.
Everything. The barons and the knights, they merely held their lands as fiefdoms at the absolute whim of the monarch.
Right, so if the king needed to fund a war, or maybe he just didn't like a particular baron that week, he could revoke the land, seize the castle, and there was no legal recourse.
No.
The king was the law.
And that arbitrary power was the catalyst for the Magna Carta in 1215. The barons finally forced King John to sign the charter, and the sources highlight that a key concession was the right of inheritance and, crucially, the restriction of arbitrary land seizures for unpaid taxes.
Okay.
The text explains that this initiated a slow democratization of property rights. The highest land title obtainable in England beneath the king's own allodial title became known as title in fee simple.
And the manual argues that when the American colonists rebelled and severed ties with the British crown, they didn't just reject the king, they absorbed his sovereign capacity.
That's exactly their argument.
The founders allegedly chose a allodial title, transferred via this thing called a land patent, as the ultimate form of ownership for the American people. The logic is that there is no king in America, therefore every citizen assumes the status of a king over their own property.
That is the philosophical core. But, the authors are not merely philosophers.
No, they present themselves as legal tacticians.
Very much so. If the Federal Reserve and the modern banking apparatus trapped this allodial title in 1913 through hypothecation, the manual claims to hold the highly specific, multi-step bureaucratic map to break that trap and extract the land.
And this is where Augustus Blackstone enters the picture.
Yes.
He took Joe Stevens' original work and heavily revised it. Blackstone seems kind of obsessed with procedural perfection.
Oh, he really is. In his foreword, he actively critiques the earlier methods. He compares sloppy legal theory to saying a nail equals a shoe equals a horse equals a saddle equals a theory.
Right, like jumping to conclusions without doing the paperwork right.
Exactly. He demands a really rigid, technically flawless approach to navigating the county recorder offices and the legal system.
Because Blackstone's methodology is incredibly rigid, because he believes the modern administrative state is deeply hostile to these actions.
Right. He lays out a sequence of mandatory hurdles to restore the allodial character of the land.
So let's break down the mechanics of Blackstone's process, because this is where the theory hits the pavement. The very first step he requires has absolutely nothing to do with real estate.
Yeah.
He says you have to restore your own personal status to that of a sovereign elector.
Right.
What is the mechanical difference between a sovereign elector and just a standard U.S. citizen in this framework?
Well, in their legal lexicon, a standard U.S. citizen is legally defined as a subject.
A subject.
An entity entirely subordinate to the jurisdiction and statutes of the federal corporation. They argue that you cannot hold a allodial title if you are a subject, just as a serf in medieval England could not hold a allodial title against the king.
Okay, that logic tracks within their system. But how does one become a subject?
The mechanism that supposedly strips you of your sovereign status is the adhesion contract.
Adhesion contracts. That is a massive theme in these materials. They argue that you voluntarily surrender your common law rights by signing up for government benefits or privileges.
Exactly. They point to getting a driver's license, registering to vote, applying for a social security number.
All the normal stuff you do just to exist in society.
Right. The mechanical argument regarding the driver's license is actually a perfect example of this.
Walk us through that.
Under their interpretation of the common law, you have a fundamental, unalienable right to travel on the public right-of-ways. However, when you apply for a driver's license, you are legally asking the state for permission to operate a motor vehicle in commerce.
In commerce?
Yes. You are trading a common law right for a state-granted statutory privilege. By signing that application, you are entering into an adhesion contract, a take-it-or-leave-it agreement, where you voluntarily submit to the state's motor vehicle codes, their equity courts, and their jurisdiction.
So to become a sovereign elector, Blackstone essentially demands you rescind all those signatures.
You have to actively unravel your contractual ties to the state before you even look at your property deed.
That sounds exhausting. But okay, once you have allegedly rehabilitated your sovereign status, Blackstone's second major step targets the county-level administration.
Right.
Specifically, he mandates removing the title from the Torrens registry system, at least in jurisdictions where it applies.
Yes, that's a critical step for him.
I need you to explain the Torrens system, because the manual treats it like this vault where the state locks away true ownership. What is it, and how does it supposedly trap the title?
So the Torrens system historically developed in Australia and got adopted in various parts of the U.S.
Right.
It's a method of land registration where the state actually guarantees the title. In a traditional recording system, a title company researches a long chain of past deeds to prove ownership. But in the Torrens system, a state court reviews the evidence and issues a single certificate of title.
I mean, that sounds efficient. Why do the authors view it as a trap?
Because of the legal mechanism underlying that certificate.
Okay.
The sources argue that by entering your land into the Torrens system, you are essentially conveying the paramount title to the state in trust.
Oh, so you give it to them and they let you use it.
Exactly. The state holds the true title in its registry, and in exchange, it issues you a certificate granting you the right to use the property, subject to their rules and, of course, their taxes. It centralizes control.
So Blackstone argues You must completely withdraw the property from this state-controlled trust mechanism to sever their claim.
Exactly. Which leads to the third hurdle.
And practically speaking, the most insurmountable one for the average person, right?
Oh, definitely. Blackstone says you must completely eliminate any beneficial interest held by lending institutions.
Meaning you cannot execute a land patent if you have a mortgage.
Right. The mortgage represents a competing claim on the land. But the texts go even further than just paying off the loan. They argue the debt must be settled in lawful money.
Lawful money meaning like silver or gold coin, not Federal Reserve notes.
Because they consider Federal Reserve notes to be debt instruments, not actual money. Though I will say they do concede that legally clearing the lien with the bank by any accepted means is the practical requirement. You just have to get the bank off the title.
Okay. So once the mortgage is cleared, the Torrens registration is broken, and your sovereign status is supposedly reclaimed, you reach the grand finale,
The main event.
bringing the original land patent forward.
Yes. The manual instructs the individual to obtain a certified copy of the original land patent for their specific plot of land. You get this from the Bureau of Land Management.
Wait, so this is the original document where the U.S. government first transferred that piece of the frontier to a private citizen back in, like, the 1800s.
Precisely. You find that original patent, and you fill out a highly specific legal document called a Declaration of Assignee's Update of Patent.
Okay.
This document is designed to legally link your modern identity to the original allodial grant from the sovereign government. You get it notarized, and you force the county recorder to file it on the public record.
And the manual cites some heavy case law to back up the impenetrable nature of this document, right?
Oh, they have a whole list. Yeah. They reference Stanton v. Sullivan, quoting the court's stance that an estate in perpetuity is in fact allodial in its nature.
Mm-hmm.
They lean heavily on leading fighter v. County of Gregory, highlighting this quote. Patents are issued between sovereigns, and deeds are executed by persons and private corporations without those sovereign powers.
So they portray the land patent as the absolute highest possible evidence of title, superior to any tax, lien, or zoning ordinance.
That's the claim.
I mean, I have to push back on the logistics here for a second.
Sure.
If updating a land patent acts as this absolute impenetrable force field against property taxes, if it is truly unimpeachable at law, as the quote suggests, why is property tax universal?
Right.
If a loophole this massive existed, every wealthy landowner in the country would have an army of lawyers executing land patents to save millions of dollars.
That's the logical question. And the authors address this skepticism by pointing to the deliberate obfuscation by the legal profession.
So it's a cover-up.
Right. They argue that lawyers and judges are officers of the court bound to uphold the statutory system that essentially employs them. But, beyond the conspiratorial arguments regarding why this isn't widespread, we really have to examine the profound psychological appeal of this framework for the listener.
Yeah, it taps into something very deep in the American psyche.
It does. It speaks directly to a primal desire for absolute autonomy and unassailable security.
Like the old saying.
Exactly. The text references the ancient legal maxim, every man's house is his castle. We live in an era where individuals feel increasingly buffeted by macroeconomic forces, relentless inflation, opaque bureaucratic regulations, endless taxation.
It's overwhelming.
So the proposition that a forgotten esoteric legal procedure can magically grant you absolute immunity from the modern world, it is incredibly seductive. It is the promise of reclaiming a rugged, idealized individualism.
It acts as the ultimate trump card. In their narrative, you drop the land patent on the county assessor's desk, and the state just has to pack up its bags and walk away.
That's the dream.
But the authors aren't naive about the government's reaction, are they?
No, not at all. They warn that the system will not surrender quietly.
Once you start filing these sovereign documents and refusing to pay property taxes, the state will inevitably mobilize its enforcement arm. They will drag you into court.
And that brings us to the second major theater of war in this deep dive.
The battleground of the judiciary.
Exactly. This is where we transition our focus from the real estate manuals into the law lectures from the court university curriculum.
The audio lectures.
Yes. These lectures and study guides establish a fundamental critical divide in American jurisprudence. They argue there are two distinct types of courts operating today, and understanding the difference is essentially a matter of legal life and death.
Okay, lay it out for us.
You have courts of equity, which they interchangeably refer to as statutory or admiralty courts. And you have courts of law, which strictly administer the common law,
This was the concept that fundamentally shifted how I view a courtroom when I was reading this.
Oh, yeah.
Yeah, because when someone gets a speeding ticket or, faces a zoning violation and goes to the local courthouse, they assume they are walking into a court of law.
Naturally.
But the lectures assert they are absolutely not. You are walking into a court of equity.
And that distinction is paramount in their worldview. In a modern equity court, the judge operates with staggering discretion. The lecturer traces the historical lineage of equity courts back to medieval England. When a dispute arose that was not strictly covered by the rigid common law, or if the common law provided no adequate remedy, a citizen could petition the king directly for fairness, for equity.
Okay.
But the king, busy with wars and statecraft, delegated these petitions to his chancellor.
So the chancellor's job wasn't to apply a rigid law, but to just, look at the situation and decide what felt fair based on his own conscience.
Yes, and the lectures argue that in a modern statutory court, the judge is functioning exactly like the king's chancellor. The lecturer points out that in equity, the judge essentially makes up the law on the spot.
That's a terrifying thought.
Right. The judge can suspend rules of evidence, bypass constitutional protections, and is free to dictate outcomes based on their own discretion, or, as the lecturer warns, their indiscretion.
The text describes these equity courts as enforcement mechanisms for statutory and code laws. But here is the fascinating twist in their logic. We elect legislatures to write statutes. We assume statutes are the law of the land. But the lectures argue that, to a true sovereign, these statutes are merely advisory. They basically treat the entire state code like a corporate terms of service agreement.
That is a highly accurate comparison of their legal theory. The lecturer argues that statutes only apply to subjects who have contracted into the jurisdiction.
Like checking a box online.
Exactly. If you click Agree at the bottom of a software update, you are bound by the terms. If you apply for a marriage license or a business license, you are contracting with the state, and therefore you fall under the jurisdiction of the equity court enforcing those specific statutes.
But if you have rescinded those adhesion contracts like Blackstone advised back in Step 1, the equity court theoretically has no jurisdiction over you.
Right, but it's not that simple because the judge has tricks.
Right, let's talk about the mechanics of how a judge maintains control. Because the texts mention this thing called the parens patriae trap.
Oh, this is crucial.
If you walk into an equity court trying to defend your land patent, how does the judge legally outmaneuver you?
The legal doctrine of parens patriae translates to parent of the nation. It is the doctrine granting the inherent power and authority of the state to protect persons who are legally unable to act on their own behalf.
Historically, this meant minors,
Yeah.
right, or individuals deemed mentally incompetent.
Yes, but the lectures argue the court applies this to sovereigns who make procedural mistakes.
Wow.
The warning in the study guides is that if you enter an equity court and argue incompetently, or crucially, if you hire an attorney to represent you, you are falling right into the trap.
Wait, if you hire a lawyer?
Yes, attorneys are legally officers of the court. By hiring an officer of the court to speak for you, the texts argue you are implicitly declaring yourself a ward of the court, incompetent to handle your own affairs.
Oh, I see.
The judge immediately assumes the parent patriae role, treats you as a ward of the state, ignores your sovereign claims entirely, and just rules against you in equity.
Man, it's like a jurisdictional minefield.
Yeah.
So what is the countermeasure?
The sources insist that a sovereign individual must actively pull their case out of the statutory equity court and force it into a true court of record.
A court of record. And that operates under the strict rules of the common law.
Exactly. The study guides provide the 5 requirements of a court of record, drawn directly from historical definitions in Black's Law Dictionary.
Okay, let's hear them.
First, the court must keep a permanent record of the proceedings.
Makes sense.
Second, and this is the most radical departure from modern practice, it must be a tribunal independent of the magistrate.
Okay, stop right there. Independent of the magistrate.
Yes.
Because in every courtroom I've ever seen, the judge is the absolute dictator of the room. How can a court be independent of the judge?
Well, in a true common law court of record, the magistrate, the judge, is merely an administrator. They wear the robe, they keep order, but they do not decide the law, and they cannot dictate the outcome.
Wow. So the true power lies elsewhere in the room.
It does.
We will definitely get to who holds that power in a moment. What are the other 3 requirements?
The third requirement is that the court proceeds according to the common law, meaning it relies on historical precedent and the unwritten law of the land, not legislative statutes.
Not the stuff passed by politicians.
Right. Fourth, it possesses the power to fine or imprison for contempt. And fifth, it uses a seal to authenticate its records.
So if a sovereign gets dragged into traffic court or tax court, they need a mechanical tool to change venues.
They do.
And the lectures suggest using a common law, writ of habeas corpus.
Yes.
Usually we hear about habeas corpus in movies when someone is, illegally detained in a jail cell demanding to be brought before a judge. How do they use it here?
They view habeas corpus not just as a physical release from jail, but as a jurisdictional extraction tool.
A jurisdictional extraction tool. I like that.
If an equity court attempts to assert jurisdiction over a sovereign, perhaps by threatening them with contempt or restricting their liberty via a summons, the sovereign files a writ of habeas corpus to demand the legal justification for the detainment.
To force the issue.
The strategy is to use the writ to force the matter out of the administrative statutory domain and into a common law venue where the chancellor loses all their dictatorial powers.
Which brings us back to the power dynamic in the room. If you successfully move your case to a court of record, and the judge is reduced to basically a guy in a robe acting like a referee blowing a whistle who actually holds the power to decide who wins and loses.
According to the entire philosophical weight of these texts, the ultimate power in a courtroom does not sit on the elevated bench. It sits in the jury box.
The petite jury.
Yes.
The classic 12 angry men.
But the lectures spend a vast amount of time dissecting and completely redefining what a jury is actually supposed to be. In the common law tradition, the 12-person petite jury is viewed as the ultimate stabilizer of society.
The final circuit breaker.
Exactly. It prevents the collective power of the state from tyrannizing the individual. And the most critical, non-negotiable aspect of this mechanism is that it requires a 100% unanimous vote for a conviction.
Now, for the listener, this might sound obvious regarding criminal trials. If you are tried for a felony today, you generally need 12 out of 12 jurors to convict.
While true for criminal cases, the lectures highlight a creeping erosion of this principle in other areas. They point to jurisdictions, like California, for example, where civil cases have been modified by statute to allow for 10 out of 12 jurors to reach a binding verdict.
And the lecturer argues this is a catastrophic degradation of rights.
A total collapse. The text asserts that changing the unanimous requirement to a majority rule fundamentally converts a republic mechanism into a democracy mechanism.
Let's explore that distinction, because they use those words very specifically, and we often use republic and democracy interchangeably in casual conversation.
Right, but in the lexicon of these lectures, a republic is a system designed specifically to protect the minority of one against the will of the collective.
Yeah.
If it requires 12 out of 12 jurors to strip you of your property, a single holdout juror can protect you.
Right.
A democracy, by contrast, is defined in these texts essentially as mob rule.
Yeah.
If 51% of the people, or 10 out of 12 jurors, can vote to take your land, the individual has no true protection.
It's the old analogy, right? A democracy is two wolves and a sheep voting on what to have for dinner. A republic is a well-armed sheep contesting the vote.
Perfect analogy.
And the unanimous jury is the armament. But the numerical requirement is only half the battle.
It is.
The far more complex issue is the composition of the jury itself. The phrase we hear constantly is a jury of your peers. I've always assumed that simply meant an impartial sampling of people from my local county pulled from the DMV database.
That assumption is exactly what the texts claim is the fatal flaw in modern justice. They trace the word peer back to its feudal origins. Historically, a peer meant a member of the peerage, the nobility.
Okay, so not just anybody off the street.
No, and the lecturer provides an incredibly visceral historical analogy to explain why the number 12 was chosen.
Oh, the force ratio analogy.
Precisely. In medieval England, a nobleman commanded an army.
Right.
When a dispute arose, you didn't just have 12 random peasants deciding the outcome. You assembled 12 noblemen. Those 12 noblemen represented 12 distinct standing armies. Add the king's army, and you have 13 standing armies.
Okay.
If the 12 noblemen reached a unanimous agreement alongside the king, it created a 13-to-1 force ratio against whoever was on trial.
So if you are the defendant and you have one army and 13 armies are arrayed against you in agreement, resistance is mathematically futile.
Exactly. The verdict guarantees peace in the realm because nobody can fight those odds.
Wow. I mean, today, the literal armies are gone. But the text argues the legal concept remains intact. A peer must possess sovereign power. in the context of the American Republic, the nobility is supposedly the people themselves.
Yes. But here is where the linguistic trap snaps shut. The lectures draw a massive, impenetrable wall between the people and citizens.
What is the mechanical difference? Because those sound like the exact same thing to me.
According to this legal theory, a citizen is fundamentally a subject. A citizen is someone born or naturalized and subject to the jurisdiction of the United States.
Meaning they have submitted to the statutes and the adhesion contracts.
Right. A sovereign, one of the people, is the creator of the government. They are subject to no higher earthly authority.
Okay.
Therefore, the logic dictates that if you are a sovereign who has reclaimed your allodial status, a jury composed of U.S. citizens is legally not a jury of your peers. They are subjects judging a king.
That is wild. And this theory leads directly to that wildly memorable San Diego case recounted in the lectures.
Oh, that case. The lecturer admits the story is anecdotal hearsay, but he stands fiercely by the legal logic it demonstrates.
Walk us through how that played out in the courtroom, because it's fascinating.
So the narrative involves a defendant in San Diego who understood this distinction and demanded a true common law jury of his peers.
Okay.
During the voir dire process, the questioning of potential jurors, the defense attorney asked a very specific question of the jury pool. He asked if they were U.S. citizens.
And of course, everyone says yes.
Exactly. Every single potential juror raised their hand and admitted to being a citizen, subject to the jurisdiction of the state and federal government. Not a single person in the pool claimed to be an independent sovereign member of the people.
So the defense attorney turns to the judge and says, Your Honor, none of these people are my client's peers. You have failed to provide a constitutional jury.
Yes. And according to the anecdote, the judge was forced to acknowledge the legal definition. He actually ordered the local sheriff to go out onto the streets of San Diego and round up actual peers.
Which means?
He needed the sheriff to find 12 individuals who were not U.S. citizens subject to the jurisdiction, but were sovereign people of California.
Which is practically impossible in a modern city where everyone has a driver's license, a social security number, registered to vote. The sheriff must have come back empty-handed.
He couldn't fulfill the order. Because the court could not satisfy the fundamental constitutional requirement of providing a jury of peers, the anecdote claims the court lacked the jurisdiction to proceed.
So what happened?
The case allegedly had to be dismissed.
It operates like a logical paradox you deploy against the state. If I demand a peer and the system can only produce subjects, the system cannot legally judge me.
That's the argument.
That's a fascinating defensive maneuver, and it ties deeply into their absolute faith in jury nullification.
Ah, yes. Jury nullification is the most potent weapon of the petite jury. The text quotes a Supreme Court case, U.S. v. Doherty, which acknowledges that the jury has an unreviewable power to acquit a defendant regardless of the evidence.
This is the concept of judging the law, not just the facts.
Correct. In a standard statutory court, the judge will instruct the jury that they are only there to decide the facts. Did John steal the horse?
Right. And the judge decides if stealing horses is illegal.
But in a true common law framework, the jury judges both. They decide if John stole the horse, and they also have the power to decide if the law against stealing horses is just and applicable in this specific instance.
So if a sovereign is brought into court for refusing to pay property taxes on his land patent, the jury can say, yes, factually, he didn't pay the tax, but we, as the jury, find the property tax law itself to be oppressive and unconstitutional.
Exactly. They vote not guilty, and the sovereign walks free.
The jury acts as the great leveler. If the legislature passes an oppressive statute, 12 randomly selected sovereigns have the ultimate authority to simply refuse to enforce it, and the government is powerless to overturn that acquittal.
Right. It is a meticulously constructed defensive shield.
When you stack these concepts together, it creates an absolute defensive fortress. You filed your land patent to protect the dirt under your feet. The government attempts to breach the walls by dragging you to an equity court.
And you deploy a writ of habeas corpus to force the battle into a court of record.
Then you demand a jury of your sovereign peers. And if even a single one of those 12 peers recognizes your allodial right, the prosecution fails.
It's brilliant defensively. But defensive shields, by definition, only protect you when the state initiates the attack. They are reactive.
Right.
What happens when the people need to be proactive? What happens when the government apparatus itself becomes systematically corrupt, ignoring land patents, stacking equity courts, and the people need a sword to strike back?
And that, listeners, is the absolute centerpiece of this deep dive.
Mm-hmm.
This is where we cross the Rubicon into Law Lecture 801. We are moving past the defensive posture of the 12-person petite jury and stepping into the shadow of the ultimate, unchecked, offensive authority in this entire legal framework.
The common law grand jury.
The grand jury.
Yes. This is the specific mechanism that, according to the lecturers and the authors, the modern state is most terrified of. The staggering power of the true common law grand jury is derived directly from the original text of the Magna Carta of 1215, specifically Article 61.
Okay, let's explore the mechanics of Article 61, because Lecture 801 details this with forensic precision. First of all, the numbers matter.
They matter immensely.
A true common law grand jury is not 12 people like a trial jury. It is not 23 people like a modern federal grand jury. To wield the power of Article 61, it must consist of exactly 25 people.
Exactly 25. And crucially, they must be sovereigns. In the original language of the Magna Carta, these were the 25 barons of the nobility. Today, in their framework, it must be 25 sovereign electors.
The most startling aspect of this 25-person grand jury isn't just their power, it's how they are formed. They are completely self-electing.
This is a vital distinction from everything we know about modern juries. There is no judge randomly selecting names from a voter registration pool.
No summons in the mail.
No. There is no state-sanctioned voir dire process controlled by a prosecutor. The lecture states explicitly. There are no external rules for how this grand jury gets elected. It simply comes into existence on its own energy among the people.
Any group of 25 sovereigns can just physically assemble, declare themselves a common law grand jury, and in that instant, they theoretically possess the world-altering power of Article 61.
That is the literal assertion of the text.
I have to challenge the logistics of this. It sounds like a recipe for absolute anarchy. Theoretically, based on this lecture, 25 guys who are mad about local zoning laws could meet up at a local McDonald's, declare themselves a grand jury over some French fries, and legally decide to seize the mayor's house.
Right.
How does this actually work in the physical world without descending into chaos?
Well, the lecturer is surprisingly pragmatic about this exact scenario. He acknowledges that technically, yes, 25 sovereigns could assemble at a McDonald's and invoke the power, but he issues a severe warning against it. Yeah, he notes that doing this on a whim, without deep education and structural credibility, will, in his words, get your tail in a wringer.
Meaning the actual police will just arrest you for trespassing or extortion, regardless of what the Magna Carta says.
Exactly. The lecturer advises that if you are going to form a true grand jury, you must project unquestionable authority.
How do you do that?
He suggests that the 25 individuals should walk into the county courthouse, approach the court administrator, and formally demand a room to meet in. You conduct the business of the grand jury right inside the government's own buildings to establish standing and credibility.
Wow, you demand the high ground. You make them accommodate you.
Exactly.
But let's look at the actual authority they are wielding, because Lecture 801 outlines a two-step procedure that is breathtakingly methodical. It's not just a mob with pitchforks. It's a highly structured legal assault.
Right. The protocol is derived strictly from the text of the Magna Carta. Step 1 is the warning phase.
Okay, the warning phase.
Let us assume the grand jury has identified a grievance, say, a corrupt judge or a mayor violating constitutional rights. The 25 members do not all march into the office at once. 4 members of the grand jury are selected as a vanguard.
Just 4.
Just 4. They approach the government official and formally present the grievance.
And they give the government a strict, non-negotiable countdown clock, right? 40 days.
A mandatory 40-day grace period. The 4 representatives notify the official of the error and demand redress within 40 days. It is a built-in mechanism for the government to self-correct without further escalation.
Which seems fair. But step 2 is where the absolute, unreviewable power engages. What happens on day 41 if the mayor ignores them?
If the grievance remains uncorrected, the 4 representatives report the failure back to the other 21 members. At that exact moment, the full 25-member grand jury is authorized to use any means necessary to force compliance.
Any means necessary. That is a terrifyingly broad legal standard.
It is. The lecture states their decisions at this point are final, absolute, and cannot be reviewed by any court.
The state Supreme Court cannot issue a stay.
No.
The United States Supreme Court cannot overturn their finding.
Absolutely not. The grand jury becomes the final supreme arbiter of the law.
Man. So what can they actually do?
The enforcement powers granted under Article 61 are medieval in their scope.
Literally medieval.
Literally. The 25 barons, or today, the 25 sovereigns, are legally authorized to destroy and in every way in their power, namely by taking our castles, lands, and possessions.
You can take the castles?
They can legally seize the private and public property of the offending officials. They can strip an elected official of their office immediately.
But there are limitations, though, right? The lecture is very specific about the boundaries of this power.
Yes, the limitations are narrow but absolute. The grand jury cannot kill the king or the government personnel.
Good to know.
They cannot kill the officials' families. And interestingly, they cannot put the officials in jail. They do not have the power of imprisonment or execution.
So, short of murder and throwing the mayor in a dungeon, a group of 25 self-appointed people has infinite legal authority to bankrupt, evict, and destroy the career of any government official who steps out of line.
That's the framework. But the most fascinating mechanical aspect of this enforcement phase is how it deals with the reality of state violence.
Right, because if the 25 sovereigns demand the mayor's resignation and attempt to seize his property, the mayor will simply call the SWAT team. How does a grand jury practically enforce its will against an armed state apparatus?
A piece of paper from 1215 doesn't stop a bullet.
Exactly.
So the text highlights a psychological and legal mechanism built into the Magna Carta regarding public support. The king didn't just agree to let the 25 barons punish him. He pre-authorized the general public to assist the grand jury.
Pre-authorized.
Yes. The Magna Carta legally binds the citizens of the land to help the 25 oppress the king if he violates the charter.
Wow. The king essentially signed a suicide pact for his own tyranny. He told the entire population, if I mess up, and these 25 guys say I messed up, all of you are legally required to help them overthrow me.
Precisely. The entire theory relies on a critical mass of public awakening. The grand jury's power is theoretical unless the broader public recognizes their authority over the local police force. It is the ultimate dead man's switch for a corrupt state.
But this brings up a massive procedural hurdle.
Oh, there are many.
Getting 25 people in a room consistently is a logistical nightmare. I mean, getting 25 people to agree on what kind of pizza to order is hard enough, let alone agreeing to systematically overthrow a corrupt county supervisor.
True.
What happens if the state tries to physically prevent the grand jury from assembling?
The lecture covers this contingency under the rules of forum and quorum.
Forum and quorum.
Yes. Under the specific rules of the Magna Carta, the quorum is established by whoever actually manages to show up to a summoned meeting.
Okay, explain how that works mechanically.
Well, if the 25-person grand jury issues a summons for its members to convene, and the government, perhaps aware of the impending action, sets up roadblocks or arrests members on trumped-up charges or otherwise forcefully impedes them from attending, the grand jury is not dissolved.
It's not.
No. The lecturer points out that if only 2 members manage to bypass the blockades and reach the meeting place, those 2 individuals constitute the quorum.
Wait, really? So 2 guys who managed to sneak past the state police could wield the absolute unchecked power of the 25 to strip the mayor of his lands and castles?
Yes.
It is a breathtaking, almost cinematic interpretation of legal authority.
It is a system designed to be completely indestructible once initialized. It cannot be legally reviewed, and it cannot be physically dispersed by preventing attendance.
Which raises the most obvious, glaring question for you, the listener, sitting at home processing this. If this incredible, world-altering power exists in the common law, and if the Constitution supposedly preserves the common law, why do we never hear about 25-person grand juries today?
Right.
Why isn't a grand jury overthrowing a corrupt city council every Tuesday?
Well, the sources claim this absence is no accident. They assert it is the result of careful, deliberate, and mathematical design by the modern state. And this brings us back to the question you asked at the very beginning of this deep dive.
The statutory grand jury illusion.
Yes.
Right. When we hear the phrase grand jury on the evening news, they are not talking about 25 sovereign barons enforcing the Magna Carta.
No, not at all. Modern American grand juries are what the lectures categorize as statutory or legislative grand juries. They are creatures of state and federal code, not the common law. And if you pay very close attention to the structural math, you will notice a consistent pattern across jurisdictions. Statutory grand juries typically consist of 21, 23, or sometimes as few as 17 members.
They are mathematically capped. They never reach 25.
Never 25. The lecturer presents this as the magic number theory. The government intentionally ensures that grand juries are capped at a maximum of 23 or 24 members.
Because if they hit 25.
By keeping the numbers strictly under 25, the state ensures that the jury never technically meets the threshold requirement to trigger the absolute, unreviewable powers of Magna Carta, Article 61.
That is just. It is a brilliant, insidious administrative trick. They give the public a grand jury in name to provide the illusion of civilian oversight, but they mathematically neuter it so it can never actually threaten the state apparatus.
It's a simulacrum of justice. Because they are created by statute and capped below the magic number, these modern grand juries are purely advisory entities.
Think about how they operate mechanically, right?
Yeah, they do not self-assemble. The members are pre-selected by judges from state-controlled voter rolls. They are shepherded into court-assigned spaces. And most critically, they are controlled entirely by state or federal prosecutors.
The prosecutor decides what witnesses they hear from, what evidence they see, and what laws they are asked to consider.
Exactly. The lecturer emphasizes a key distinction. Statutory grand juries have legal power, meaning power on paper within the confines of the state code, but they possess no lawful substance under the common law. They cannot independently indict a corrupt prosecutor because the prosecutor controls the room.
The lecturer tells a highly specific illustrative story about Orange County, California, that perfectly demonstrates the impotence of the statutory grand jury, doesn't he?
Yes, the data processing department anecdote, it's a perfect encapsulation of their argument.
Right. So a standard statutory grand jury in Orange County spent considerable time investigating the county's computer and data processing department. They did their job exactly as the public expects.
They audited the department, found massive government waste, disorganization, incompetence, and they issued a scathing, highly critical public report.
And how did the government respond?
A county supervisor simply went to the local press and completely dismissed the findings. He essentially waved a hand and said, well, that's just the grand jury's opinion. They don't really understand how complex data processing works, so we're just going to ignore the report.
The arrogance.
The lecturer's point in highlighting this arrogance is sharp and vital. That county supervisor could only get away with dismissing the grand jury because he knew, structurally, he was dealing with a statutory advisory body. He knew they had no teeth.
Because if that had been a true common law grand jury of 25 sovereigns...
If that had been an Article 61 grand jury, the supervisor could not have dismissed the report as a mere opinion. The grand jury would not have needed the prosecutor to file charges. They would have possessed the direct, unreviewable authority to remove that supervisor from his elected office on the spot and potentially seize his personal assets for malfeasance in office. The state relies on the fact that the jury was capped at 23.
So, if we take a step back and look at the entire massive tapestry these sources have woven, from the dirt in your backyard to the paperwork in the county recorder's office to the jury box in the courthouse, it describes a silent, ongoing war.
It really does.
The sources argue there is a fundamental tension between what they call the system run in on us, the Federal Reserve banking apparatus holding the underlying title to land, the tax collectors, the equity judges making up rules as chancellors, and the dormant sleeping power of the people.
The entire modern system, according to this intricate framework, relies on a psychological submission.
Yeah.
It relies on the people forgetting who they actually are. It relies on them forgetting that they hold the ultimate trump card in their own hands. The lecturers actually cite Etienne de la Boétie,
the 16th century French philosopher.
Yes, who wrote the Discourse on Voluntary Servitude.
What was his core argument?
He observed how quickly and thoroughly as subject people can fall into such complete forgetfulness of their own freedom that they can hardly be roused to the point of regaining it. He argued that tyrants only have the power that the people voluntarily surrender to them.
And the lectures update that philosophy for the modern era. They compare modern American compliance to the famous psychological shock tests.
The Milgram experiment.
Yes, the experiment conducted after World War II designed to test obedience to authority. The researchers tested whether average Americans would obey orders to administer lethal electric shocks to a stranger.
Right.
And the terrifying result was that a massive majority went all the way to lethal voltage simply because an authority figure wearing a white lab coat told them it was required.
The sources draw a direct parallel here. They are arguing that the modern public is blindly obeying the equity judges, the tax assessors, the zoning boards, handing over their wealth and their property rights simply because the state wears the authoritative robe and badge.
It is a deeply compelling, albeit highly controversial, narrative of lost liberty.
It is.
The texts we've explored today are essentially a treasure map, offering a highly specific, bureaucratic way out of the maze of the modern administrative state.
We can trace the path they've laid out. Step 1. Reclaim your sovereign elector status and sever the adhesion contracts binding you to the state.
Cancel the driver's license, the voter registration.
Step 2. File your land patent to secure absolute allodial title and rip your property out of the feudal property tax system and the Torrens registry.
Pay off the mortgage in lawful money.
Right. Step 3. If challenged by the state, deploy a writ of habeas corpus to force the government out of their rigged equity courts and into a true court of record,
Where the judge is just a referee.
Step 4. Demand a jury of your sovereign peers who possess the power of nullification.
And Step 5, the absolute nuclear option.
Assemble 25 sovereigns into an Article 61 grand jury to actively dismantle the corruption from the top down.
It is an incredibly intricate, internally consistent, entirely alternate operating system for reality. We started this journey by looking at our standard property deeds and exploring the unsettling claim that they might just be color of title, a sophisticated legal illusion of ownership that keeps us paying perpetual rent to this state.
Right, and we learned how the obscure process of land patents attempts to reclaim absolute allodial sovereignty, aiming to sever ties to the 1913 Federal Reserve hypothecation trap.
We waded into the murky jurisdictional waters of statutory courts versus common law courts, exploring the theory that modern judges either act as dictatorial equity chancellors or mere administrators in a court of record.
And finally, we unearthed the hidden, mathematically capped, unreviewable power of the 25-person common law grand jury as the ultimate historical check on the power of the state.
It is a staggering amount of dense legal and historical theory to process.
It really is. And as we stated at the beginning, whether you view these texts as a forgotten master key to true constitutional liberty or as a highly dangerous, fundamentally flawed misinterpretation of medieval history, they highlight a foundational question that every society must inevitably face.
Exactly. I'm talking directly to you, the listener, as you process everything we've unpacked today. Where does the ultimate authority in a society truly reside?
Does it live in the complex, impenetrable codes of the legislature, enforced by chancellors and prosecutors?
Or does it reside in the raw, unrefined hands of the people sitting in a jury box? If the system is fundamentally broken, who possesses the lawful right to fix it? And by what authority do they act?
This exploration raises one final, highly provocative question for you to mull over, a philosophical and logistical thought experiment that wasn't directly answered in the discussion of these texts.
Oh, this is a good one.
If true sovereignty rests with the individual, and if any 25 sovereign people can self-assemble to form an absolute, unreviewable grand jury under the Magna Carta, what happens when two different groups of 25 people form competing grand juries with completely opposite demands?
That is the ultimate paradox of absolute power.
If Grand Jury A decides the mayor is corrupt and must be removed from office and stripped of his lands, but Grand Jury B decides the mayor is righteous and that Grand Jury A's property should be seized for treason, who arbitrates the dispute? Who controls the absolute power of the people when the people violently disagree with themselves?
When everyone believes they are a sovereign king, what happens when the kingdoms inevitably collide? The real law might not be a dusty document in a county recorder's office. It might just be whoever has the critical mass to decide what reality is going to be today. Thank you for joining us on this extensive deep dive into the source material. We'll see you next time.